guardians, but also for lay guardians. And rather than say that all the standards of practice of professional guardians should be applicable to lay guardians, we decided to first address standards of practice that were raised by the conference for professional guardians, and then to address issues of standards of practice for lay guardians. Another priority from the August 7th conference was to develop new or revised standards of practice for professional guardians, discuss the possibility of restricting the number of appointments a professional guardian may accept, determine if and or when a professional guardian may petition to become the guardian for someone other than a member of his or her family, define conflict of interest and determine if and or when it's appropriate for a professional guardian to serve in multiple roles, that is guardian, guardian ad litem, attorney, trustee, representative payee, attorney in fact. And as you saw from the earlier slides, we've really addressed a few of those already. Then develop guidance that helps clarify what fees a guardian should charge. Other priorities for new and revised standards of practice for professional guardians would be to define social hospitality, that is, what's a cup of coffee, and clarify if and, I won't say let's define is, but I did say let's define it. Define social hospitality, that is, a cup of coffee, and clarify and or when a guardian may accept a gift from a person to whom they provide guardianship services. Develop a standard practice stating that guardians can limit and or restrict contact with friends and family of a person in a guardianship only after documenting the reason for the limitation and or restriction, notifying the individual possibly facing restriction and giving them an opportunity to respond and or correct improper behavior. Again, these are priorities from the August 7th conference. Develop a standard practice requiring the use of generally accepted accounting principles, standardized timesheets, supporting documents that would be accepted into every court by every judicial officer, and develop a standard practice specifying financial standards based on the amount of assets owned by the person in a guardianship. So, regarding our vision status, significant progress in development and recommendation that wings encourage and or advocate adoption of standards, guidelines, and best practices for entities involved in the delivery of decision support, including courts, guardians, guardians ad litem, attorneys and other professionals. Status summary statement, the standards and best practice committee responsibilities are probably on track with a 12 to 24 month time frame. I think some of us feel like not necessarily, but we're trying to be optimistic. Questions? And I really appreciate this picture of me that was discovered when once upon a time in a planet along, in a galaxy far, far away when I had hair. Any questions? Yes?
I've encountered a case that struck me as unusual where the court-appointed guardian, a certified professional guardian, recognized that since the respondent or the ward was a majority owner of a limited liability company that had vast holdings, the professional guardian appointed itself, used her authority as majority owner of that limited liability company to appoint itself as manager of that limited liability company. So I'm wondering if you're addressing conflicts might also include, when the guardian uses their authority as guardian to appoint themselves to some other position that's not closely supervised by the court.
We potentially can, yes. My recollection is there's a standard of practice regarding professional guardians and what services they can contract for and what close relationships they can use in doing those. So one could, I think, either deduce from those standards, and I don't recall them explicitly off the top of my head right now, but either deduce from those standards of practice the conflict and the problematic nature of that, or more explicitly address it if the standards aren't sufficiently explicit, And in terms of what you specifically talk about, I don't recall, Shirley, and please help me, I don't recall if there is a specific standard of practice for the situation you described. It may be that we can address that in the conflicts of interest to be addressed. Yes?
Will you be looking at all at performance standards for the court-appointed attorneys who are representing the alleged incapacitated persons? I haven't found any performance standards for the attorneys we have for lay guardians, certified professional guardians, and GALs. But I haven't seen any for court-appointed attorneys.
That's not explicitly on our agenda. I think we can say that it's implicit in our recommendation for mandatory appointment of counsel and provision for waiver. The next step after mandatory appointment of counsel and provision for waiver would be what are the standards of performance for court-appointed attorneys. In other states, there are, depending on the state, there are standards for such appointments, including some controversy regarding whether that role is zealous advocacy or best interest, and the inclination of national standards and national conference recommendations is a zealous advocacy approach, and then some states spell out what that zealous advocacy approach is in contrast to the guardian ad litem role of best interest examination. Thank you. I've got one down here while you're, can I take?
Take that.
Okay.
I just wonder how I can get a copy of what you're showing.
Shirley, I assume the slides are going to be available? They're on the website as we speak.
They will be posted. They're not.
Oh, they will be. Thank you, Shirley. Other questions?
Yes, I was just wondering, these are proposed revised standards of practice. What is the policy for final approval of these to put them into play? What's the final process look like?
Yeah, my understanding, Shirley, and help me, is that these are recommendations that go to the.
Certified professional guardianship board.
Okay.
That's the certified guardians. The board has to approve all standards. And so these recommendations will go to the board. That's the sequence.
Okay, and I guess for clarification, so with respect to the wings process, do the recommendations of a particular committee go to the steering committee, or do they go directly to the board?
They go to the steering committee first. Thank you for the question. So our recommendations from our committees and committees must first go to the wing steering committee, and then the wing steering committee approves, and then they will go to a certified professional guardian.
Or other appropriate recipient among stakeholders. Is that responsive? Yeah, these are recommendations. Yes.
Shall I speak up? I'm very interested to see the isolation question on our list and some interesting protective steps to take. I also am quite sure there's many people in the community that think that this type of protection can't come soon enough. But also see that it tends to circle like the legislation. The legislative session this year didn't take much action, and it looks like a good idea to think about it will continue. It's not that it's gone away. I think one of the problems with isolation seems to be that it's not very carefully defined. It slips around like a kind of slippery animal. It reminds me of the expression, well, I know it when I see it, which long ago a Supreme Court justice, I think it was assigned to the pornography idea. But isolation is a little bit simpler, but I think we still go by I'll know it when I see it, and yet the definitions of isolation are lacking. Is it about telephone calls? Is it about private mail? Is it about saying to a potential visitor, so-and-so doesn't really want to see you, so you can't do that today? That might be untrue. I would like to suggest that this definition of isolation is something that needs to be worked on, and I wonder if it's going to fall into the hopper.
I'm not sure about the legislative hopper this year, but as far as the responsibility of this committee to try and address it, it's pretty clear that we've got at least one or two August 7th recommendations that are on that issue. There are in other states statutory provisions for addressing the issue. As you know, there are at least two sides to it. On the one hand, some guardianships are in place because there are family controversies and issues and difficulties. On the other hand, there are reports of some guardians who inappropriately limit contact with somebody who's under the guardianship. So it's an important and controversial issue. There are standards of practice that are available on a national basis, and there are statutory provisions in other states that are available for assistance, guidance, consultation.
As I think many of us know, that probably in most communities there's a certain identifiable list of attorneys that are recognized as having a guardianship practice. And so if a family member feels that there should be a guardianship initiated for a relative or family member, they will probably get steered to one of those quote guardianship attorneys. And that guardianship attorney may very well counsel their client to recommend the appointment of a particular professional guardian, who then subsequently is appointed. But then if the family member starts having concerns about the performance of that professional guardian, their lawyer quickly resigns, saying, "Oh, I represent that professional guardian at times." And have in the past, not in this case, but they have in a small community. Have represented that professional guardian in the past and probably will again in the future. And I'm trying to think, how can this be addressed so that the naive family member who seeks a guardianship can be informed early on that their attorney is recommending a professional guardian with whom that attorney has had an historic attorney-client relationship. And it occurs to me that's a conflict that it's the attorney should be forthcoming, but maybe isn't, probably isn't. But it could be cured if the professional guardian, when they file their statement of qualifications, indicates that they have had in the past an attorney-client relationship with some attorney involved in the case, such as the petitioner's attorney. At least if the client, the petitioning client, sees that statement of qualifications, at least then it raises the issue and they can have a discussion with their attorney.
Yes. The committee struggled to try and address that kind of issue, and you can see in our recommendations the extent to which we may or may not have been successful. We certainly as a matter of practice, whether it's regulated or legislated or just a matter of practice, erring on the side of disclosure, as we heard from a number of the stakeholders on our committee, is an appropriate way of proceeding. And most attorneys, most guardians perform and behave appropriately most of the time. It's the challenge of the few who don't that you try and address in the form of regulation, if not legislation. So we tried to address it in a couple of the proposed standards of practice. We'd be happy if you'd review them at your leisure and give us some feedback about those, or if there are any shortcomings regarding what we have. And we certainly are going to continue to be trying to address those kinds of conflicts. I'm tentative because of the challenge of getting disparate stakeholders to agree on some of these questions. Various stakeholders understandably tend to err on one side or the other, and the sides they tend to err on are not necessarily the same. So getting a consensus is challenging. But certainly as a matter of best practice, we heard from any number of our committee stakeholders that it is a practice, whether it's necessarily required or not, by many to err on the side of disclosure. And if even more people would err on the side of disclosing, then of course there would be less need to regulate.
And I remember when there was some discussion about this, that even with the attorney and the GAO and the guardian, we're not sure who actually sees the statement of complications. And then we didn't want to put that burden on the layperson to even understand what that statement means, or to understand that that's not that. So there's some questions about it. It was discussed.
Yeah, as you see, several of our recommendations are fairly lengthy, and they attempt to delineate a number of the conditions, but aren't guaranteed to be exhaustive.
Thank you.
Thank you.
So next, we have the long-range planning committee.
All right. I think so. So, Shirley, how do I advance this? So let me just get you through. There you go.
Okay. And just press the forward, the right
No,
button.
we went backward. We went backwards. All right, there we go. Here we go. All right. That's the one hi. This is all right,
So
great.
you go to the next one.
Yes. So hello, everybody. I'm Lisa Brodoff, and this is Larry Weiser, and we are the honored co-chairs of the Long Range Planning Committee. And so I'm going to first talk about our committee, what its mission is, and at least as we've interpreted it, and then the process that we've used to move forward on our priorities. And then Larry will describe where we are on each of the priorities that we've been given. So first, who is here? Please stand if you're on the Long Range Planning Committee. We have a really good group, a diverse group, lawyers, guardians, long-term care ombudsman, a really good group, and really been working very hard. So what is our mission so far, as we understand it? So we are supposed to be taking the long view, long into the future, of how we can improve the system of decisional support in our state. We've been asked to develop effective proposals to improve decisional support and to be advocates and leaders towards this goal. So that's been our big mission, and I think it's fair to say that we have struggled sometimes to understand the scope of our task and how to accomplish it. And some things we struggle with is, how are we different than other committees? How are we different than the legislative committee? Can we suggest policies that aren't necessarily within the scope of priorities we've been given? How do we work? Do we work with other committees? What about other stakeholders? What do these priorities mean that we were given? And what happens if we see other issues that aren't specifically stated? So that's just to let you know, sort of struggling at the beginning with what does it mean to be on the Long Range Planning Committee. So we decided, though, to start our big task by setting up a process by which we could move forward, because it seemed sort of too big without having a method, a structure of going forward. So here's what we decided. Let me go to our next slide. We decided to take each of the priorities that we were given and set up subcommittees to work to tackle each one with a sub-chair who would organize the work and the meetings and then report back to the big committee. So let me just tell you what our priorities that we were given are. The top thing we were supposed to do is look at how we could support the family and friends of people who need decisional support. How do we support them? This is from the Wings, the first Wings conference. And and in particular to look at reduced fee legal advice for family and friends. So that was number one within our top priority. Number two, within the supporting family and friends needing decisional support, was to look at providing access to conflict resolution, alternative dispute resolution, family mediation for family and friends of persons needing decisional support. That's the second one. And the third priority was to provide court-appointed attorneys to the person in the subject to the guardianship. Very important priority. Those were the top three things within priority one. Our second priority was to improve the assessment of people needing decisional support. And there's one priority within that. Number four was to establish minimum qualifications for guardians ad litem. Then the third priority was how can we improve guardianship standards and practice? And number five within that was to provide education and assistance, and in particular establishing a hotline for guardianship questions. And then we have 6, 7, and 8 within that third priority of improving guardianship standards and practice was to improve professional guardianship certification, and then to require Washington State and FBI background checks before lay guardians are appointed, and finally to improve, number 8, to improve minimum qualifications for all guardians. So that was our task. Those were all the priorities we were given from the Wings 1 Conference for Long-Range Planning. So then how did we approach each priority? So as I said, we set up subcommittees for each one, and we set up a structure to decide what to do. The first thing we did was want to figure out, what does the priority mean? What is it? What does it mean, and what is its current status? So the first thing each subcommittee did was determine what is the nature of the problem that the priority hopes for us to address, and describe it. And then, what is currently in practice to address the issue? So is this a problem that already has a solution that we have in statute or policy elsewhere, or not? So what's currently in place? And then C, let's look elsewhere. How have other jurisdictions or places addressed this issue that may be different than how ours, that may be better or not? So that was the next part. And then D was then, what are the options we think are available that would work in our state? So then, having done that whole process, then we would go on to decide on the best options to address the priority, and then finally decide what steps need to be taken to achieve this option. So this kind of a structure gave us a place to go and a place to start on each of these long-range plans. And we're here to report that we did make some significant progress already on some of our top priorities, especially priority 2, 3, 4, and 5. And I can report that we have made no real progress on our top priority, and also on priorities 6, 7, and 8. But Shirley told us when we last met that we are not in a big rush, that we are the long-range planning committee, and therefore we did not need to come up with solutions for all priorities in our first 3 months of existence, and that was a huge relief for us. So we've slowed down a bit and focused in our efforts to start, and Larry is going to report on our progress on the priorities we did do.
Okay, thank you, Lisa.
Yeah.
Lisa and I go back. We both teach. Well, I just retired from Gonzaga Law School, and I did 34 years of a elder law clinic and taught elder law, and I taught ADR as well. Lisa taught elder law, did an elder law clinic. I play saxophone and clarinet, and
I played bass and sing.
And we're not in the same band, but we have played together with the Funk Pro Tunk band many years ago. But Funk Pro Tunk, isn't that cool, man? So just trying to get a little levity in the afternoon after lunch. So,
I like to say that I started practicing elder law at age 25.
yes.
And now I have grown, I'm now 60, and I've like grown into my age, into the my client group, and now I can represent myself for free. So,
Yeah, when I
thank you.
Yeah, I was
one joke.
I was 32 when I
Yeah.
started 34 years ago, and when I saw in the application somebody was 60, and they said, "Oh my, I feel so bad, they're so old. Well, we have to take care of them." And now,
Here we are.
I'm 67, so okay. So let's talk about what we reported. The first one is I'm the subcommittee for providing access to conflict resolution, and that's deep in my heart because I did teach ADR, and I am a mediator, and in my retirement I'm doing mediation, guardianships, and probates in the States, and so the new elder care mediation practice, and I think it's wonderful. So provide access to conflict resolution. So the statute does require mandatory mediation if requested by a GAL or the AIP. And the TEDRA also requires any party to a dispute can require mediation of the conflict within the statute's jurisdiction, which also includes guardianship matters. And so one of the issues is why guardianship disputes are not mediated on a more regular basis. Why are we not? Why are cases going to court? Why can't we do mediation? Because you bring everybody into the room, and usually it involves families, and a mediation, it can be a more peaceful way to resolve the conflict within the family. And I've seen it so many times in mediation. So we want the courts, we want everybody and we want to understand why it's not being done on a regular basis. And there might be some dynamics with that, with guardian ad litem. Some guardian ad litem say that they mediate, and is that appropriate? The other thing, not on the list, but things that I am thinking about too, and Karen Mount's here too. Is she still here? Yeah, hi Karen. Is what I'm really interested in: early dispute resolution. Before things have to go to court, and that is a big area right now. And also training for mediators, because I think that there's, the Center for Social Gerontology in Michigan, Ann Arbor, had some materials years ago talking about that special training for mediators in guardianship proceedings and how to have the AIP participate in the proceedings. And I can tell you that involving the AIP in the mediation process, if you do it correctly and you do it with respect and understanding, that it helps tremendously, especially with families. And the other thing, somebody contacted me on a dispute resolution centers, and they might be a good resource, but we're also going to look at what resources are available in the state and look at other states' guardianship provisions and see if we can improve in conflict resolution in guardianship matters. Okay. The committee provide a court-appointed an attorney, and the initial goal and recommendation of the August proceedings was to appoint counsel for an AIP at all stages of the guardianship process. And so the different options that are presented is maintain existing law governing the availability of counsel to represent alleged and adjudicated incapacitated persons. So not just at the beginning, but post guardianship matters. Option 2, ensure counsel is provided to represent all alleged and adjudicated incapacitated persons. And option 3, provide additional protections to ensure that counsel is available to alleged and adjudicated incapacitated persons who would benefit from representation. So there are 3 different options, and they have different ramifications. And I know Carla Calgera is here. Here. And she is the chair of that committee, and looking at all the different issues that are involved. And we're like Lisa said, we're at the beginning, and it's fascinating to discuss these things. And for me, personally, having, the guardianship takes care of the frail, and, we have public defenders. We need to have people who represent our incapacitated persons adequately. So, okay. Minimum qualifications for GALs. Dan Smirkin, Lonnie Waden is the sub-chair. Is she here today? Okay. Oops. Okay. The current recommendations for minimum qualifications for GAL sounds like the Academy Awards.
Yeah.
Is.
Here's the envelope.
Okay. The minimum education requirement for GAL should be a bachelor's degree, any discipline. Require GALs to look for a less restrictive alternative, needs to be codified in the law as well, and refer issue to a legislative committee to implement recommendations. And this is something that we need to process, like Lisa said, in our committees, because as we go on, we want to, we might refer some matters to the legislative committee. And priority 5, establish a hotline for guardianship questions. I don't know if anybody, I know, is Anna here from the Spokane County Superior Court? Okay, GMP, Guardianship Management Monitoring Program. She probably sees so many lay guardians come to her office all the time. And, having some forms is nice, and having understandable forms and uniform forms, but the procedure is really difficult. And then post-guardianship, I think, is where a lot of people get into problems. They're really well-intentioned, but they have to file all these, annual reports and all the time, and then they get called into court if they haven't done it. So if we had a hotline for guardianship questions, I think that would be really, really helpful. And there's a report, I don't know if that says that, nope. Okay, there is a report that Karen that wrote that is really sort of is the initial view of the problem. And as you might think, it's really difficult, to gather all the different resources, getting funding, and then putting something like this together on a statewide basis. So I think this committee is going to be really, really important, because I think that the success of our guardianship program is to access family members so that they can be, do their job as a guardian. Oh, questions? Go ahead.
Yes, just wondering if you were aware that yesterday a report was filed with the Washington Supreme Court about the issue of mandatory appointment to counsel, and whether you'll be looking at that. And from a long-range perspective, considering the application of the Americans with Disabilities Act to guardianship proceedings, and viewing the appointment of counsel as an accommodation to the alleged incapacitated person or the respondent proceeding to make sure they have access to justice.
Yeah. So, answer to your first question, I found out about 2 hours ago from you, and I am looking forward to reading it, and I'm sure Carla is, and then looking at that. And certainly there's an ADA component that has to be discussed, but the committee hasn't really flushed that out. But I am sure it's essential that they will. And so all the different aspects of this, lawyers make it very complicated, and this very complicated issue will be considered in the future committee. Yes.
Yeah.
As a lay guardian since 91, I've had my private battles with Social Security and the SHS innumerable times. It would be very helpful if a list of experts or attorneys in that area could be published, both mono or paid. I've had a paid attorney who put in the middle of
Yeah, I think that actually goes somewhat to our top priority, which is providing assistance to family and friends of people needing decisional support through reduced fee or other methods. So we'll note that for to consider that having at least resource pages and availability of pro bono and reduced fee. Thank you. Yes. So thank you for that suggestion.
And having a hotline and website will
also help yeah.
that. So I think that those are things that can be considered together. All right. Well, thank you very much.
Thank you. Yeah.
My name is Walt Bowen. I'm the chair of the Wings Legislative Committee, and I'll just give you a little briefing of what we're up to. I'm president of the Senior Citizens Lobby. I'm not an attorney and I'm not a guardian, but I know a whole lot of them. And the Senior Lobby is made up of 37 member organizations, all of whom have some kind of contact on a regular basis with guardians and have some interest in an issue, pretty strong interest in fact. So that's how we got involved with this. We're one of the sponsors of the Wings program, and we're quite proud to be doing this. Things we're interested in have to do with the age wave and with the soon to be 20% of the state's population of 7 million will be over 65. So there's lots more folks that will be coming on that likely to be needing guardians services. So we're quite interested in those. The mission of the committee is to provide advice and recommendations on all matters dealing with legislation, including court rules, to Wings. During the active legislative session, the committee will monitor bills of potential interest to the Wings, which is the contracted program with the courts system here, and select those to be tracked. The committee may recommend positions on bills for considerations by the full Wings Steering Committee. So we don't, on behalf of Wings, lobby directly. We come up with recommendations. Those recommendations go to the Steering Committee, which the Steering Committee gives us or makes decisions on how to deal with the recommendations, as they do with all the other committees. So there's 20 members of the committee. We've met by phone about 5 times, and I met face to face with the members of the committee for the first time since the committee was formed. And so some of those committee members are here. I wonder if you'd all stand. The folks on the legislative committee. That's okay. We have 20, so yes. And it's kind of interesting to discuss some complex issues without being able to see someone, but we've been able to make some progress on that. With us today is Representative Lori Jenkins. Is she still here? She's the chair of she's the chair of the House Judiciary Committee, and so the Judiciary Committee is very interested in this topic as well. So one of the things that recommendations from the committee will be developing issues or looking at issues and maybe have some recommendations. And we have a vehicle this interim session, because the way the legislature works time-wise is a 2-year session. We're right now in the 2015-16 biennial session. So last year was the first year. This is the second year, if it ends, of what it ends up being the session. So there were no bills passed this time, but there's still many issues of concern to a lot of folks. So in the interim, we're not waiting till 2017, because that would be the next time that the legislature would be in session to take up any issues. So in the interim, we are fortunate to have a vehicle to discuss with the legislature issues having to do with guardianship. And this is the Joint Legislative Committee on Elder Issues and Disabilities. JLEC is the term for it. After this session ends, whenever that is, That committee, which is made up of equal numbers of Democrats and Republicans from the House and the Senate, and other members of the state government, they will meet and in the interim and discuss a number of issues, and one of those topics will be guardianship. So we'll be discussing issues related to guardianship with that committee. That committee then makes a recommendation to the 2017 legislature. That committee's recommendations are due on December 31st of this year. So in the interim of the legislature, we'll have a chance to discuss the guardianship issues with the legislature. Whenever the legislative committee has meetings, the new TVW recording system is up and running now. It's all super digital, and we'll let you know when those hearings are. Will be broadcast, and if you're interested, you can watch on TVW on your laptop or whatever mechanism to keep track. So you can stay informed about the legislative issues. So we basically our menu for our work was driven by problems that were identified at the Wenatchee conference, and so that was our main menu to work with to begin with, and they were issues that people felt, if were addressed, might improve the delivery of guardianship services. So we surveyed 50 states on definitions, and we recommended not changing the guardian ad litem. The next steps we're going to be the high-level milestones. We have visions to change to deal with the guardian ad litem, choose more information, sources, hostile and formal names. One of the things we found in our discussions that sometimes recommendations might appear to improve something at first, but when it gets into it, some of the solutions end up being more difficult than the word or issue that was trying to be changed. So we worked through those things. The status, we're still working on it, it's not quite on track. The next one is the high-level project milestones, reconstructing the protected persons, visions, the vision status for the change in IP and AIP, and use respectful language. And so those are some of the choices we dealt with. And this project is closer to completion than it was when we got going on it. We surveyed stakeholders regarding the use of a mandatory and pattern forms. There's other groups we understand that are working on this situation as well. So we'll be continuing to discuss the pattern forms, and then discuss other options and proposals using agreed to decision-making protocol, and then looking at develop a statewide court rule describing the use of standardized tools and forms, as I mentioned already. So the next priorities are develop a proposal for statewide guardianship monitoring, develop a proposal for guardianship ombudsman, and develop a proposal for credential guardians ad litem. So, questions? Fantastic. Happy St. Patrick's Day, and have a good time.
So next up we have the Information and Training Committee, and that is Meredith Childers is the chair, and there's some sub-chairs as well.
Come on down. If you're Charlotte and team members. Do you want to stand up here with me? Oh, okay. More chairs. No, I think actually this is perfect. We need 4 chairs and Charlotte and I will stand. Hi, everyone. You're the diehards. You've stayed. Congratulations. I'm Meredith Childers. This is Charlotte Jensen. And then I'm going to introduce the team members in a minute. But we're the Information and Training Committee, and our task is to develop and recommend development of educational resources and training materials for guardianship stakeholders. And just to give you an idea, we've subdivided into subcommittees. So you'll see the 4 major committees, and then here's our Information and Training Committee. And we are divided into the Court Monitoring Subcommittee, Guardian Information and Training Subcommittee, and the Website Subcommittee. Charlotte is the chair of the Court Monitoring Subcommittee, and she'll talk to you about the work that they've done. I'm the chair of the Guardian Information and Training Subcommittee, and I'll talk with you. And then we've divided our first project, which we'll talk about, is to work on a handbook for lay guardians. And so we've divided, in a sense, specifically by the chapter of the handbook. And so these wonderful team leaders who've taken on the task of leading the team to work on that chapter of the handbook. So that's how we're organized. And then is Donna Holt here today? I didn't see. Okay. Donna Holt is the chair of the website subcommittee. Her job doesn't quite go into effect until we've got content for the website and start to update that content. So we're pushing that out a little bit. And this is the list of our members by committee, subcommittee, and team. And I understand this PowerPoint's going out to you guys, so if you want to look more closely at some of these slides, because I'm going to whip through, like Walt said, we're between you and the highway. Okay, you're up.
Okay. Good afternoon. My subcommittee, it has been just a great opportunity to work with them. And I'd like to just point out who they are. Kristen Denton is the Skagit County Guardianship Monitoring Program Manager, and she is also a deputy clerk, so she wears 2 hats. She has just an incredible width and breadth of knowledge, just like the rest of our team members. She's in the Skagit County Clerk's Office. Anna Kemmerer, who I know is here, she's in the back, and we asked her to talk earlier. She's the Spokane County Guardianship Monitoring Program Coordinator, Spokane County Superior Court. Deborah Jameson, I don't know if she is here right now. She's an attorney. She's with the law firm of Neal & Neal. She's had several years in the private practice working with guardianship. She also served as a guardian ad litem in King County, and she also worked at the AOC. Fauna Sugg, she is a court administrator in Chelan County Superior Court, and she does their guardianship monitoring. And my name's Charlotte Jensen. I'm the Court Business Information Coordinator at the Administrative Office of the Courts. And like I said, it was my pleasure to work with these people, and this topic is near and dear to my heart. And so what we were asked to do was to look at the court processes and come up with practices, suggestions, recommendations for court monitoring programs. So one of the things, our key accomplishment was that we spent a lot of time talking about these processes and milestones, and we identified and categorized strategies that can be implemented in Washington courts to facilitate guardianship monitoring. And where this is kind of interesting is, I'm sure a lot of you know this, but Washington has 39 counties, 39 superior courts, and 39 county clerk's offices. We are a non-unified court system. So even though we have a centralized case management system on the Superior Court side, except for Pierce, who uses links, these counties process cases using what works best for them. So a pro for this is that courts process cases using resources, policies, and procedures that suit their respective jurisdiction. The con, courts process cases using resources, policies, and procedures that suit their respective jurisdiction. So, as I said earlier in my presentation, it was really clear that there is no cookie cutter approach. Okay, some counties have guardianship monitoring programs right now. They're doing a fantastic job, and really focusing on making sure that things get done on time, working with all the guardians and doing training. Other courts do not. Simply thinking about King County, who currently has an inventory of 5,700 active guardianship cases, versus Asotin County, who has 48. The guardianship monitoring program in King County wouldn't fit with Asotin County, who has 48. And Asotin shares one judge with 3 counties, and that court administrator serves for all 3 counties and works with the judge. So, we really had to be cognizant of these varying levels of resources when we started thinking about what could work for a court who currently doesn't have a monitoring program to start one. And so that's what we did. We came up with a list of several and based it upon what could a minimal guardianship program look like, median, and then an optimal program. And the PowerPoint is also going to be available on the website, so you can look at that. Our next step is for the courts. We want to provide support to the courts to develop and expand guardianship monitoring, tracking, reporting, and guardian accountability. Our hope is that if a court has not started a guardianship monitoring program, that they will take at least one of these recommendations and start. We've even talked about how do I take the first step, giving them this information. And if the courts that have one, take another step, incorporate another recommendation. It was also important for us to consider that we are recommending that courts provide the guardians, lay, certified attorneys with tools that they need in order to ensure guardianship monitoring compliance. They need the documents. So it's been a privilege working on this thus far, and I have a feeling that it's not over yet, right, Shirley? And I look forward to working on this in the future. Thank you.
We'll take questions about the court monitoring program right now.
Good job. Yeah, sounds great. Yeah, thank you so much. All right, you guys, on to Guardian information and training. There were several recommendations or top priorities that came out of the first WINGS conference in Wenatchee. They're up here on the board, but basically creating, developing a training for professionals, in-person training for lay guardians, a manual for lay guardians, developing opportunities for mentoring, and developing a petitioning packet that includes the entire guardian process. So we decided on our first project, which is to develop a statewide lay guardian manual. And there are several great examples out there. King County has a lay guardian manual. Spokane has several manuals. This is the guardian training handbook, but they have one for lay guardians as well. Snohomish, there are several examples out there that we're looking at and considering in creating an updated statewide manual. And as I said before, we just came up with 4 main chapters of the manual and then divided into what I'm calling teams or committees by those chapters. And we've spent the past bit of time brainstorming within our teams about what content we want to put into the handbook. And what I asked each team to do was to come up with a very draft table of contents that we could show you today. Obviously, there's more to do, and we met before and talked about, what more is there to do, who do we involve, and we've got a lot of that planning to do. But in the meantime, we've thought about what we'd like to include in the handbook. Monica's team, the introduction and alternative, Monica's here in the green, woohoo, St. Patrick's Day. Introduction and alternatives to guardianship chapter. Then we have guardian of the person reporting, which AIM, this is your team, right? AIM's team. Guardianship of the estate reporting, which is Suzanne, who gave, both Suzanne and Monica gave excellent presentations today. I really appreciate the information we got from them. And then Katrina is doing what we're calling the beyond reporting team. So all the other things that guardians do and need to consider, which is a big task for you and your team. But we're working forward. We came up with a project plan, very loose again, and we're going to keep working together on this project and then consider more of the recommendations as we move along. As Lisa was saying, we were told we have copious amounts of time. But we do, as you see, then as soon as I heard that, then I made a project plan so that we would stay on target. But in any case, that's what we're working on right now. As I said before, Donna Holt is the chair of the website subcommittee, and her task comes a bit later as we're developing content. She's going to be working on that, and some of our team will move into her team, and we'll move forward from there. But that's it. I whipped through it so you could go get your green beer. But questions? This is going to be up on, Shirley's going to send this out, so you'll get some more time, and others who've had to go will get more time to look at it. We would love your comments, and I know that we're going to be relying on all of you to help us with this project, because you're experts, you're the stakeholders. This manual is for you. And so we'll be asking for your help, but if you have questions, comments, suggestions in the meantime, please feel free to email me. My name is Meredith Childers, and I'm at the Northwest Justice Project, which is my email address, but we'll get that out to you as well. There's a question over here.
Have you thought about doing any trainings for people that are either suspected to be going under guardianship or under guardianship, what their rights are and just basically know about the legalities of it? I know a lot of youth, they get put into guardianship but they don't know what it is. So is there any thought about doing trainings for those people?
I love that idea, and yes. And there are materials on our website, DRW, Disability Rights Washington, and others have provided materials on that, but I love this idea of an actual training on your rights. So thank you.
Never made me down to shout.
That's shout it.
Have you considered, instead of using the phrase lay guardian, using the phrase volunteer guardian?
I think actually that's what the King County Handbook calls lay guardian. So we could make that recommendation for sure, but do you have a specific reason for, go.
I think when professionals prepare a manual and say it's for lay guardians, in some ways it's kind of a put down. It's, you're not like us. You're just, we're going to walk you through what you need to do. I think volunteer guardian is a little more complimentary of a label.
Right.
And I think more appropriate for the people that are going to be reading this.
Right. And recognizes the commitment that they made. Thank you. Yes.
In conjunction with that, one other distinction is I'm mentoring people who I call, or they call themselves, lay guardians, who are just taking one or two, and they are not going to become certified, but they're willing to take one or two, and they are charging for their time. They're not volunteers. So they're not volunteers. So I didn't want to call, I was one that was to have a designation of a volunteer. Sorry.
I feel a term recommendation coming on. This is a great discussion to have, and as we move forward, let's keep talking about it. Yes.
And I thought that I've got, I heard so many intimidated family and friends that are whatever we choose to call it. They're just overwhelmed by the decision-making process. So in order, as you're talking about, first you're talking about court reporting, and then it almost seems as an afterthought, you're talking about additional reasons. I would almost rather see in the intro and see what you've got. Both the honor and the importance of decision-making.
Yeah, and I think that's, oh, I'm sorry to interrupt you. Yeah, I think that's actually part of that introduction and alternatives. We've had that discussion, so thank you. Yeah. Yes.
Along the same thought, I noticed in your outline that under each of the reporting by person and under finances, or the estate, that then it talks about kind of some of the decision making. I like the idea of having that perhaps pulled out as a separate kind of call out, or a separate chapter, so that you can see like here's some of the decision making standards that we talked about. Here's what's going to guide you through this journey, and then, and maybe have that separate from just chapters about people.
Okay, great. Thank you. Is there another question? Yes.
My question is, have you ever thought about doing a statewide training for people with disabilities so that people with persons with disabilities want to know about guardianship?
A statewide training about people with disabilities or for people with disabilities? Yeah. I think those trainings are happening. I don't know, but it's definitely needed in our communities, and so thank you. Any other questions? All right, you guys. Thank you very much.
So all you diehards, I'm so glad that you stayed. We're at the end, and again, I want to thank you for staying. The last question I think I want to answer is what happens with WINGS now? And WINGS continues. The committees will continue working. They will continue working on the recommendations. It's our hope that we will have an annual conference like this, but until I can find additional funding, I can't make that promise. But WINGS will continue to operate, the steering committee will continue to exist, and we will move forward. And are there any other questions? If you are not serving on a committee and you would like to serve on a committee, please send me an email, and it's just my name, shirley.bondon@courts.wa.gov, and we'll get you on a committee.